Second, Senate Committee on Judiciary. Mr. Secretary, would you please call the roll?
Senator Burke. Present. Senator Carroll.
Here.
Senator Deneen.
Here.
Senator Neal. Senator Schickel.
Here.
Senator Stivers. Senator Storm.
Here.
Senator Turner.
Here.
Vice Chair Wheeler.
Here.
Chair Westerfield.
Here. Anybody have any guests they want to recognize? Seeing none. Senator Wheeler, we're up. You're up. Senate Bill 70. Members, there is a committee substitute in your folders. Motion and a second on the committee sub. I want Senator Wheeler to talk about the bill. You might have any questions about the sub or the changes made. If not, if there are, I'm happy to, since it's mine, I'm happy to walk through those.
Mr. Chairman, I thought your suggestions were very much a clarifying. They improved the bill, so I heartily endorse the committee substitute.
I appreciate that. Why don't you describe the bill, and then I'll walk through the changes.
Sure. Senate Bill 70 is a donor intent act. The purpose of the act is to ensure that charitable institutions and universities and folks that are heavily invested in receiving donations from charitable givers, that when that is done, that when an endowment is set up with an express intent that the donee, the person receiving the money, is held to account for how they expend those funds. The bill, Senate Bill 70, creates a private cause of action in the person of the donor or the donor's designated representative to bring about an enforcement action if they feel that their intent when they made their donation is not being followed. It does not require the charity to refund the money under any circumstances. It basically allows them to go to court and get an injunction to see that their original wishes were being fulfilled. I know that some folks say that this power is already vested within the Attorney General as per certain nonprofit organizations, which is true. However, as many of you all know, there are hundreds and hundreds, if not thousands, of nonprofits throughout the Commonwealth. Not saying our Attorney General or his predecessor has not done a fine job, but clearly to investigate the intent of every donor that may have a problem would potentially create a situation where they would not be able to fully investigate these specific actions, and they actually have the ultimate choice as to whether or not to take that action. So the person who gave the money, who feels like that something has been done wrong, ultimately does not have a say in the matter. I can give you several examples here today if you would like, or we can, if you have any questions. I think one of the most egregious that was given to me was the Robertson Family Foundation at Princeton University. They donated more than $35 million worth of A&P stock in 1961, which had blossomed to more. The endowment blossomed to more than $930 million that was used to fund most of the scholarship programs at the Woodrow Wilson School of Public Affairs. The Robertsons' children later concluded that Princeton was not fulfilling the terms of the endowment and filed a suit. A forensic audit revealed that Princeton, in fact, had misused more than $100 million in earmarked funds. After spending $90 million on combined legal fees without even going to trial, the Robertson family heirs reached a settlement, whereas Princeton agreed to return $100 million. After the family's fees were paid, more than $50 million went into a new foundation that is independent from the university. So what this essentially is, it's a transparency bill. It just makes sure that if you are a donor and you give large amounts of money, that you or your representative has a right to ensure that it is well spent. You cannot recover the gift, but you can enforce the gift. And that's really the crux of the bill. I guess if you want a Kentucky example, we saw, and I don't want to cast aspersions here, but, the U of L Foundation is in recent memory, the large amounts of money that were misappropriated. And I think I gave Senator Berg an article that was given to me that the J. Graham Brown Foundation, one of the largest in Kentucky, actually paused their donations to that university because of some of those actions. So This is merely to ensure that monies that are given to charities are well spent and that the people giving those monies or their designated representative have a right to ensure that through injunctive relief.
I know we've got at least one question. We may have some others, but I wanted to highlight the differences between the bill as filed and the committee sub. On page 1, line 21, not 21, line 24. The last clause in sub E, the definition of endowment fund, I believed created an exception that ate the rule, and I had that last clause struck. Reads endowment fund does not include assets in the original bill. It reads endowment fund does not include assets that an institution it designates as an endowment fund for its own use. I would say every fund is going to be designated for their own use.
Sure.
The second change is on page 2. Under sub 3C, we added some language to clarify that no monetary damages were available. I thought the language in the original draft wasn't as clear, so we wanted to clarify that this is just equitable relief.
Correct.
Injunctive or specific performance, but not money damages. And then lastly, I had the last clause in subsection 4 struck, which is on 2 and the top of 3 of the original bill. The charitable organization may do so by bringing a civil action and shall seek such declaration in any suit brought against it under this section. The weird language that was in the original bill would have required in any challenge against a nonprofit for the nonprofit to essentially counterfile or countersue for a declaratory judgment,
Yes.
which was redundant. And so I had that struck. Those were the changes. We've got a motion to second on the sub. If there are any questions, I'll entertain them now. If not, all those in favor of adopting the sub, please vote by saying aye. Aye. Those opposed? Okay. The sub is adopted. I know we have Senator Berg.
Thank you, Mr. Chairman. I have actually 2 questions, one of which I had posed the other day and was told the answer was in here, and now I don't see it. Okay. I make a $5 million endowment to whomever. I make a $5 million endowment to University of Louisville, Department of Political Science. It's an endowment for the chair. Okay? We have an agreement. I give the money. I die. My kids don't like the chair that they picked out. They don't have any standing under this, do they? They can't do anything.
In your specific example that you referenced, I don't think that they would because you endowed the chair. You didn't, endow a specific chair. But now if they took the funds and reallocated it towards the payment of, say, professors when you endowed the chair itself, then, I think your sons would have standing to bring an enforcement action.
So this standing goes in perpetuity to whoever my heirs are? Who gets this standing?
Well, I think if you set up a foundation, then, generally a lot of foundations have boards and a designee, and that person would have the right to enforce the intent of the gift.
I would think, you correct me if I'm wrong, Senator, I think the standing would last as long as the gift is there.
That's right, yeah, as long as the gift's
As
there.
long as the gift, any of my heirs would have standing?
If they meet the definition of legal representative as set forth
Yes.
here, that's what I read that to be. If the gift is still there and available to be utilized, the standing is still necessary.
I mean, most of these are done
But
through
what
like...
if
Yeah, go ahead.
my children disagree with my original intent? Can they go and change it?
No, because you're the donor. It was your
I'm
intent that
dead.
mattered. Well, I don't... You expressed your intent when you, in an instrument, when you gave the gift. I mean,
Unless
I think,
you gave them power to.
I guess I guess if you gave them power and that subsequent people could change, subsequent trustees or subsequent representatives could reinterpret my intent. I mean, you're the testator, the donor. I mean, what your wishes are paramount.
So do I designate somebody in my will to be the person responsible for this?
Normally, I think what you would do, and I mean, this is kind of going into the weeds on you might set up, say, a trust foundation to manage the money that would fund the chair, and
Yeah, but then I have to pay
they
for
may
that.
have a board and members, legal designees that if they were to later determine that the intent of your donation was being violated, they could go. Well, first they would have to send notice to the university to give them a chance to correct that action, or the nonprofit, whatever it might be. And if they refuse, then they could go to circuit court and get an injunction to enforce the intent of the gift.
Still confused.
Well, again, it would only be for gifts for with a specific intent or purpose. If you just want to give $5 million to the university, no strings attached, that's always a possibility as well. This doesn't prohibit that.
A follow-up question?
Yes, ma'am.
So when the James Graham Brown Foundation gave an endowment to University of Louisville,
I think they gave donations to the endowment. Yeah.
donations to the endowment.
Yeah.
Okay. When they wanted University of Louisville's endowment to be audited, which what this article that you gave me refers to, they felt that there was inappropriate expenditure of funds. They wanted University of Louisville to be audited, and maybe correctly so. How does their endowment give them standing on that? I don't understand.
That's the purpose of the bill, is to give them standing to enforce and to make sure the money is being spent like it was supposed to do. That is the issue. There is a question regarding whether they do have standing. This bill specifically gives them standing to do that.
Any individual donor has standing,
or foundation.
or foundation has standing to go to any major institution that they gave a significant contribution to and say, I don't like how you're using my money?
I don't think it would have to be I don't like, but if they're, for example, you endowed a law school and they decide to start using that money to pay for professors at the medical school, clearly that would be a violation of your intent, correct?
Okay, let's say I endowed a chair in the law school and I said in my endowment, this person has to be this, this, and this. I mean, I'm not even allowed to do that. I don't think I shouldn't be allowed to do that. And nobody should be able to enforce that as far as I'm concerned.
Yeah.
But let's say I did. You're saying I have an action, a legal action to go ahead and enforce that? Yeah.
You're the person giving the money. I mean, I think that, you have a right to,
All right.
Thank you.
Thank you.
Anybody else have any other questions? Senator Carroll.
Mr. Chairman, I would ask to be given a little bit of a latitude on this.
Yes, sir.
And Senator Wheeler, I want to start out with this. I appreciate your passion. I have immense respect for you, and I initially signed on to this bill on the face. It sounded good, and I, as someone who runs a nonprofit, I'm all for that. But after some meetings, there were some concerns that came up and on how this might shed light on nonprofits and maybe paint a picture that there are many issues in this. And I think there's some concern from those who represent nonprofits that that this might be misinterpreted, that there is a problem in the state with nonprofits doing this. How valid that concern is, to what level, I can't speak to that. And then the other concern is that perhaps this is not necessary, that the AG's office already takes these cases, they review them, and spoke with the AG's office this morning. They get maybe 2 complaints a month, so they are not overwhelmed by these, and the process is there. As far as how funds are invested from donors, we already have statutes that cover that, so that's not an issue. I would assume, and I've checked with at least one university, and I haven't heard back yet, that when these funds are set up, when the donation's made, I'm assuming there's paperwork that that addresses these issues. Is that correct? That basically states this is our intent, and legally binding documents that both the donor and the recipient file, correct?
I think that there are in many cases that is absolutely correct.
So that in itself, doesn't that create the ability to a cause of action if those papers are violated?
I think it's questionable. There have been instances wherein they have determined that once that the donation in and of itself is a gift, and once the gift is made, that you may have expressed what you liked it to be used for, but once that donation has occurred, you lose your standing to contest it. And what this bill is intended to do is to clarify that the donor or their legal representative would have continued standing to enforce the original intent of the gift. So it's really a clarification in the law, and I don't look at it as usurping anything from the Attorney General, merely as an additional tool in the toolbox so that the person or persons that perhaps know their intent or the intent of the donor the best, their foundation or the person themselves, can go and enforce the intent of the gift. There's nothing that requires the AG to actually take action. So you may be the donor and, say, hey, they were supposed to give all this money to use Senator Berg's example, to endow the chair of the political science department at U of L, and they're paying, 4 professors, and they're not even giving any money to the chair. Well, I talked to the department president, and they got enough money for the chair, so they thought this would be a better use of it. That we don't think there's anything actionable there. That may be their opinion, but that may not be your opinion, and you're the one that gave the money.
But if there is a legally binding agreement, and I'm not an attorney and I don't pretend to be, but if there's a legally binding agreement, then that cause of action is already there. So I guess I don't understand how this changes anything. It's a civil case. There's an agreement made. It's a contractual relationship. Both parties signed it. One agreeing to give money, one agreeing to use that money for a certain program, whatever. And if they violate that, it's a violation of contract that gives standing in civil court. That's already there. The AG's office feels that this bill will actually take these actions out of their office and it'll go into the courts. And if there's argument there that the AG's office is too busy to handle this, I think I can make an equal argument that the courts are too busy to handle these things.
I've not received, and I'm not doubting anything you say. We're good friends, and I know you're a man of your word. I've received no complaint from the AG's office about this bill whatsoever.
No, I haven't either.
And like I said, I merely look at it not as usurping anything from the AG, but simply providing additional tool for the person who actually gave the money and clarifying the position of standing, because I don't think it is quite as clear-cut as what you may think.
If you could prove that to me, I would be okay with that. But agreement's an agreement. A civil agreement is a civil agreement. If it's violated, the courts hear that regardless. So, just saying in this particular case that under these circumstances, it's a civil violation. It's a cause for action. But just to say specific it's a cause of action, please forgive me, that sounds more like a political statement than one that is based on criminal law.
Well, I'm not accusing anybody of crimes here. I mean, this is a civil action bill, but I could give you, I've got a sheet of examples. Now, granted, many of these occurred out of state, but in multiple jurisdictions there have been. So
let's talk about Kentucky, though, Senator. And there's one instance with one university, and is it worth casting that air of suspicion on all nonprofits for something that one university did?
I'm not casting any suspicion or trying to cast any suspicion on anyone, and I mean.
But this bill has the potential to do that at some level to the public that maybe doesn't know the details or understand the difference.
I would take the opposite point. I think it would strengthen people's resolve to donate to these institutions, because they know they would have a right of action if, in fact, they did not obey the expressed intent of their gift. So, I mean, if anything, I think it would give people more confidence to donate large amounts of money because they know that they themselves or their representative has a right of enforcement to make sure their intent is being performed.
I think they already know that, and I think they already have a cause of action. Again, Senator, I appreciate your passion. I appreciate what you're doing, and I'm looking at it from a different perspective
Sure.
that you are. And is it an overreaction from the nonprofit sector? I don't know. And there's an argument that really nobody pays any attention to what we do in some areas throughout the state. I get that, but our nonprofits in our state work very hard to build credibility and to be an asset to the community and provide invaluable services. And focusing attention on this when it's not necessary, there's not a history there that shows that there are issues here. There's already a cause of action established by a legal binding agreement that's signed. The AG's office is already addressing these issues. They said 2 cases a month. They're not overwhelmed by this. There is recourse there. We look to the AG all the time to make decisions, and I think they accept this responsibility. And I just don't see that this is necessary. And again, Senator, I appreciate your efforts. I appreciate the intent. And Mr. Chairman, that's all I have. And thank you for the latitude, sir.
Yes, sir. Senator Turner.
Thank you, Mr. Chairman. I would like to first make a statement. I want to thank Mr. Wheeler for bringing this, because it's my understanding as a lawyer and a practitioner, basically, that when you make a donation to some institute, it's not a contract. Basically, it's not a signed contract that gives you certain rights. And that's the whole purpose of this bill, because us lawyers know if you don't have standing, the court's going to kick you out. Now, we refer to the Attorney General as being the lead in this. And ain't the purpose of this bill, Senator Wheeler is trying to clarify this and give the people that actually put the money in there, and why some institution would say that this is going to make it look bad, or, I mean, I respect Senator Carroll's thought process and statement, but kind of disagree with it in the sense that this bill is only going to say that the people who actually put the dollars in there, that intended that, and I from my experience it's most of you hear about it is after the original donor is gone, that's when things happen. In my many years of being involved in this somewhat in donation thing, that the sole purpose of your bill is to just clarify this and say that the institution must obey the intent of the original donation.
Yes, Senator Turner, that's exactly right. I mean, and again, it's not the intention of this bill to cast aspersions. Our nonprofits in Kentucky do wonderful work, and I would never say that they don't. But if anything, this bill is merely to increase donor confidence so that they know that in addition to the avenue of the AG, that they have an additional avenue that they may pursue to merely get injunctive relief, not force the return of the donation, to merely make sure that the purpose of the gift is fulfilled.
And that's the sole purpose of it, and that's what the Attorney General would do if he had the time to do it for.
Well, if he is, but I mean, I think there could be instances where the Attorney General, even if the intent is being violated, may not want to get involved, and think is the person or the representative of the person who actually gave the money, that they should have a say. I mean, in the sense that they gave that donation with a specific purpose.
Thank you, Senator Whitaker.
Senator Storm.
Just to follow up on what Senator Turner just mentioned, donations typically are not a contract. Is that your understanding?
I think that they are generally, yes, I think that's absolutely correct. They generally are not a contract.
And this gives donors standing to fulfill their intent behind the gift, correct?
Absolutely correct.
Thank you.
Senator Carroll, last question.
Thank you, Mr. Chairman. And in most donations, I mean, you're correct. It's just, here's a check, you acknowledge receipt of the donation, you get a picture made, and you're grateful, and you take the money and provide services, and it's said and done. And I'm thinking more about these major endowments, major funds. And I would venture to say in those cases with our universities, colleges and universities, that there is an agreement signed because of the amount. I don't know that. I've asked Murray State. They were checking with their folks this morning. I haven't heard back. But I can't imagine with those amounts of money and the importance of that to the family, that there's not something signed that acknowledges the intent of that donation, that it be used for that both parties sign. And please forgive me if I'm wrong, but if that does happen, that is a legally binding document, correct?
If the court interprets it as a gift, once you make the gift, it's no longer really in your control. So that, I think, therein lies the problem. If the gift is made, even though there may be a quasi-contractual agreement as to how it's to be spent, that there have been some courts, there is a disagreement in the law amongst many states as to whether or not the donor has the right to enforce it later. So this merely clarifies it, saying they do have standing to do so.
Okay. So in a criminal court, it would be theft by failure to make required disposition of property. In a civil court, I mean, I get the difference, but is that not the same thing in a civil manner?
I think that you have to look at it whereas it may be a contractual gift, but it's still a gift. And many jurisdictions have held that the donor does not have standing once the gift is made to enforce the parameters of that gift, because essentially you've lost control of it. So this is merely clarifying that they will in fact have standing in such instances, in addition to the other potential resolution routes through the Attorney General's office.
Okay. All right. I appreciate it, and I appreciate the debate. I love this stuff. Mr. Chairman, I think we're creating a solution to a problem that doesn't exist. Thank you.
Thank you, Senator. Any other questions? Oh, no, that was the last question. Senator Berg, do you have another question? You can ask.
Thank you, Mr. Chairman. Just real quickly, let's say I wanted to be really devious, and there is a nonprofit I don't like. He said it did. And I give them $100,000 with a contract that says this money is supposed to be spent for X. And then, regardless, just because I don't like them, this scout gives me standing to take them to court, in which case they have to hire lawyers also. So we could go through that $100,000 I gave them really quickly, and I could bankrupt them by doing this. If I did not like them, it's a charity, a nonprofit that I did not agree in, I think this gives me a way, if I have my money and I'm willing to use it, to actually force them to have to defend themselves to the point where they go bankrupt. Stop me. Tell me where I'm wrong.
Well, I think the court, if it was found that it was a suit brought in bad faith, always has remedies that could be imposed for abuse of process and things like that. You could always have a counterclaim for that. So I think there's actually parameters within the law that if such a thing were done, that the court would have tools in its toolbox. And besides, I mean, the interpretation of a contract is generally something that is for the court. So I trust our judges within the Commonwealth of Kentucky to be able to filter through spurious arguments pretty quickly and get to the bottom of things.
Not without costing them a lot of money, potentially more than I gave them.
And again, if it's frivolous litigation, there is a counterclaim for abuse of process, which allows you to recover
Damages?
Damages for the person that wrongfully brought a lawsuit, yeah.
That's all the questions I'm going to permit at this
Mr.
time.
Chairman, I'd like to make a motion to table this until we can hear from the AG's office.
Do you have a position on that, Senator? Or a response?
I don't know that it's necessary. I mean, this bill's been properly posted. I've not received the first bit of feedback from the AG's office in opposition to this. I think that, again, this is not usurping any authority from the AG. The AG somebody can still file a complaint with the Attorney General, and an investigation should be made. So Yeah, I think I would object.
Yeah, Mr. President or Mr. Chairman, I am not asking for this to hear opposition, but merely to explain the process that they go through and what that covers, how in depth it is, and to really establish whether or not this legislation is necessary.
Just give me just a second, Senator.
Not sure you got the vote because I think
Yeah, but I got Whitney, I got Janine, I got Turner, I got you, I got Storm, I got me. I got 6.
Okay, we do have a motion, and I think that's what we're conferring about. I just want to make sure we're following the rule book here, and none of us have the rule book, so we're all shooting from the hip from memory here. But because there's been a motion to not take action on the bill, to table it, the nomenclature I'm drawing a blank on, and I believe it was properly made. I would ask if there is a second. Okay. All those in favor of tabling this, please vote by saying aye.
Mr. Chairman, I would ask for a roll call vote.
Okay. Mr. Secretary,
Senator
this is on the motion to table the bill.
Senator Berg.
Cast my vote and explain.
No, not on this. This is to table it or not.
Just table. No,
Just cast your vote, guys.
I'm voting yes. Yes, thank you.
Senator Carroll.
Aye.
Senator Deneen. Senator Neal. Senator Schickel. Senator Stivers. Senator Storm. Senator Turner. Vice Chair Wheeler.
No.
Chair Westerfield.
No. Bill, or the motion to lay it on the table is defeated. Do we have a motion and a second on the bill as amended? Then I'll entertain motion and a second on the bill as amended now. Motion and seconded. I'm going to say Schickel and Storm. The first two I saw. Mr. Secretary, please call the roll.
Senator Berg.
Cast my vote and explain.
Briefly, yes, ma'am.
Yeah, I am going to vote no right now. I still have concerns about how people of wealth can manipulate money. And I just need to get some more information and feel perfectly comfortable that we're not putting our nonprofits at risk. So I reserve the right to change my vote, but for now, I'm voting no. Thank you.
Senator Carroll.
Mr. Chairman, vote no and explain my vote.
Yes, sir.
I agree with the intent. I disagree with the process, but I do appreciate your efforts, Senator.
Senator Deneen.
Explain my vote.
All members can explain your vote briefly. Thank you.
I vote aye. I would like to say that I believe our nonprofits across the state, across the Commonwealth here, do an outstanding job, and I believe this would add a layer to that to ensure that donors' intents are carried out properly. So I do not have a problem with that. Thank you, sir.
Senator Neal, Senator Schickel, Senator Stivers, Senator Storm, Senator Turner,
Play my vote. I also vote aye, and it's the same purpose that the drafter is bringing this before us. It's not a bad intent because you don't have any standing, and as a lawyer, you get that knowledge of standing. You make the gift, and you lose that standing. So this gift is going to be somewhat controlled now, and the intent of that gift be controlled by this legislation by placing a standing in where it should be. And I vote aye.
Senator Wheeler,
Aye.
Chair Westerfield.
I vote aye, and the removal from the OAG in favor of a limited private right of action without the possibility of monetary damages is the most appealing part of this to me. I don't like our ongoing venture to remove private rights of action from legislation. The Constitution provided the courts for the redress of our grievances, and that's where those grievances should be brought. We give the OAG a lot of enforcement authority. I'm relieved, Senator Carroll, that they're not overwhelmed with their 2 cases a month. I don't think our courts are going to be overly burdened with those 2 cases. And I suspect that the gifts from donors that are of the size that this would be of particular concern about probably have the resources to bring that action if they wish to. That's the part that's the most appealing to me. I would like to see, and I've had conversations with Mike Biaggi about this and with Senator Wheeler about this. I'd like to see the case law that supports the standing argument. You've provided some material that indicates common law suggests that unless the gift instrument expressly provides for standing, that standing isn't there. And perhaps that's because a donation is typically not a contractual relationship. But if you can cite some cases that are persuasive for Kentucky, I'd appreciate that, or controlling standards in Kentucky. The bill passes with favorable expression on a 6-2 to no pass vote number there, or count. Seeing no other further business to come before the committee, we are adjourned.